I apologize for the abrupt ending of the first video dealing with this, but I was in the middle of saying that the first document the attorney files in a case in court, in most circumstances, it's the complaint if they're representing plaintiff, or it's the answer if they're representing defendant. But that document also serves as the attorney's entry of appearance, which lets the court know, as well as the other party, that this attorney and their firm will be representing the party throughout this case. If an attorney is to enter a case after it has already been filed, then they would draft a separate document called entry of appearance, and that would have to be filed with the court. And just a side note, dealing with that is because sometimes clients will be unhappy with their current attorney and they will seek out new representation. We talked about this a little bit when we were doing the client interview. And there's nothing wrong with a client looking for new representation if they're unhappy with their current attorney. But if a client comes to us and they already have an attorney that has filed documents in court, we can't do anything in that case as far as the court is concerned until the first attorney withdraws their appearance. Then we have to file an entry of appearance. So it does become not just a logistical issue or a technical issue, it also becomes an ethical issue of entering our appearance in a case. We cannot do that unless we're co-counsel with the existing attorney. We cannot enter our appearance until they have withdrawn their appearance. Now, if nothing has been filed in court yet, usually much easier to take care of. The attorney would just, the client would just inform the attorney that they no longer want to have them represent them, and then they can hire whoever they want. But once it's filed with the court, a lot of meaning gets attached to that attorney's entry of appearance, and it's we cannot withdraw as attorney of record without the court's opinion. So without the court's order. So there are more steps to go through once a lawsuit has been filed in terms of entering appearances and withdrawing as the official attorney of record. So I just wanted to make that clear because sometimes people are a little bit uncertain about that. So attorney information, top left-hand corner of the page in Dauphin County. Next section is the caption, and this is Rule 1018. So the caption has to be included on the first page of every document that is filed with the court. So what is included in the caption is the names of the party and identifying them as plaintiff or defendant, the court that the case is going to be filed in. So we usually say something like Court of Common Pleas, Dauphin County, Pennsylvania, whichever county it is. The docket number or the case number. This number is assigned by the Prothonotari's office when we file the case. So when we're first drafting the complaint, we have the spot for the number, but we don't actually put the number in because we don't know the number and we just can't make a number up. So we leave that blank and it's filled in when the case is filed. It identifies the type of action. So sometimes it's just civil action. Sometimes the attorneys might put more information, civil action, negligence, or complaint and negligence. There are some rules like medical malpractice cases where you have to specifically state medical malpractice, but what type of case it is, whether the party is requesting a jury trial. Now, most attorneys will put the jury request in the caption, basically killing two birds with one stone. You don't have to file another document. Under the rules, and the rules 1007.1, the request for the jury trial has to be made no later than 20 days after the filing of the last pleading. So if the answer is the last pleading that's filed in a case, you have 20 days after that to file a document requesting it. Most attorneys know if they think they want a jury trial, so they just put it in the caption of their complaint or answer. But it is something that has to be requested. And the last part of the caption is the name or title of the document. So is it a complaint, an answer, a counterclaim, a motion, a preliminary objection? What is it? So that information has to go in the caption. So with the exception of the name of the document, once you have your caption drafted and you have a case number assigned, and if it is correct, you are using that exact same caption for every document. So you're using the same caption on the notice to defend as you are in the complaint. And then you will use that in every document you file with the court after the complaint has been filed. The next part or section of the complaint is the introductory paragraph. This seems a little redundant because we've already stated the parties' names in the caption, but we do restate them here. And so it can be worded differently, and what you will find is attorneys have their own way of stating things, and however they want it is how you're going to do it, whether you think it has to be that way or not. I know attorneys, we tend to like things the way we like things, and sometimes we think that's the only way it can be done, even though there are options. You're just going to have to do it the way your attorney wants it. So it usually starts with something like, now comes plaintiff Mary Smith by her attorney Kathleen Mack, Hack law firm, and states against defendant John Doe as follows. And so it's really usually just a couple lines long, but that is your introductory paragraph. Every document you file with court is going to have some sort of introductory paragraph that comes right after the caption and the title of the document. So it just always has to be tweaked for what you're actually filing. So that is the introductory paragraph. Then we get into the actual paragraphs. And these are, you can find information about this in Rule 1022 of Pennsylvania Rules of Civil Procedure. So Rule 1022 paragraphs. And really, this is a short and sweet rule. It basically just says that the that the pleading will be divided into numbered paragraphs, and that these paragraphs are numbered consecutively. And each paragraph will contain one material allegation. So it's a very short rule, but it gives us a huge amount of information about how we write paragraphs. So first thing to always keep in mind, especially if you are a creative writer or if you have a journalism background, this pleading writing is very different than that. And so I know through the years, sometimes my students who struggle the most with this are actually very good writers, but they just have to train their brain to think differently when they're writing a complaint or answer or counterclaim. So it's not like essay writing, because we're writing in this numbered paragraph form. And then you're going to state facts. This is not opinions. It is facts about your client's case, about the jurisdiction and venue allegations that you're making, about the story of your client, about the causes of action that you are alleging. And each one of those is going to be in a numbered paragraph, and it's only going to be one material fact per paragraph. And so again, it's just a different way of writing. So if you're, writing an essay in an English comp course, it's going to be very different than writing your client story in a pleading. Pennsylvania is a fact pleading state, which means that we have to allege the main or material facts of your claim. We just can't state generally that defendant did something and caused harm to plaintiff. We have to actually state the facts that support our claim. And this is stated in Rule 1019. Specifically, the material facts on which a cause of action or defense is based shall be stated in a concise and summary form. So that is fact pleading. Federal courts, they are more notice pleading, and by rule they are notice pleading. But in practice, they're, from what I understand, they're tending to be more of a cross between notice pleading and fact pleading, but Pennsylvania state trial courts are definitely fact pleading. So again, each paragraph must contain only one main allegation. So you can have more than one sentence in a paragraph, but there's only one main idea, so to speak, to that paragraph. And especially as a new complaint writer or a new pleading writer, always use more rather than fewer paragraphs. So when in doubt, use more paragraphs to tell your story and to state all the facts of your case as opposed to fewer. Because if you use fewer paragraphs, you're going to be more likely to put more than one main idea or fact in that paragraph. And so if err on the side of caution, use more paragraphs. It's much easier to start out more basic and then enhance it or become more complicated later than it is to do the reverse. And so, if you turn in an assignment, your complaint assignment, and you have 31 sentence paragraphs, I am going to be fine with that, because if it is well written and if every paragraph has one main fact, you are consistent with the rules, and that's what you're supposed to do. So always err on having more paragraphs rather than fewer, especially initially. Although I think you will find that as a general rule, that will serve you very well whenever you're writing complaints. Another piece that people really get confused on when they do the assignment is that the paragraphs are numbered consecutively, which means you start at number 1 and you just keep numbering them all the way through the document. You will never start over numbering in a complaint or an answer or a counterclaim. And so what will happen is sometimes when people get into the counts, they want to start over with number 1. But think of it as a practical matter. You're in court and you're referencing paragraph 5 of the complaint. If there's more than one paragraph 5, how will anybody know what paragraph 5 you're talking about? And so there can only be one numbered paragraph for each number in a pleading. So you never repeat any of the numbers in your numbered paragraph. So that is why we sometimes have complaints that have 50 paragraphs or 100 paragraphs, depending on how complicated the case is. Okay, so what do we put in those paragraphs? So already mentioned, the first paragraphs always deal with jurisdiction and venue. So that's why we start the semester talking about jurisdiction and venue, because these are going to be our first allegations. Who are the parties and what is their state of residence? So we've already talked about legal state of residence. That is the information that we include in those first paragraphs. So we would have a paragraph for plaintiff and a paragraph for defendant, because it's one main allegation per paragraph. If you have more than one plaintiff or more than one defendant, each plaintiff, each defendant would have their own paragraph. Then we will allege venue. So since we're in state court, venue is going to be dealing with what county do these parties reside in. And when we talked about proper venue for in a case would be, where defendant can be served, which is usually where they live or work, or where the cause of action occurred. So we're putting in where the parties actually live. In most cases, we can certainly expand on that if we need to find proper venue. And so so we have to allege the county. So you'll see when we write the complaint and we write addresses, it's going to always be something like Harrisburg, Dauphin County, Pennsylvania. And so we're always going to list, street address, city, county, state, because we need county for venue purposes. Federal court, we would be identifying the district that the parties live in. After we get done alleging jurisdiction and venue, then we get into our fact allegation. So this is client story. So this is our factual theory that we talked about the other day. And so again, in our numbered paragraph format, so say it takes us 4 paragraphs to allege jurisdiction and venue. Paragraph number 5, we're going to start talking about client story. When I write in the materials that we're going to include the common fact allegations, what I mean by common fact allegations is we frequently have more than one cause of action in a case. We have a couple different negligence claims or a breach of contract in a negligence claim. You're going to put all the fact allegations in this particular section. And so, basically what happened, when it happened, who did what, those types of information will go there. At this point, we're not specifically mentioning the legal terminology related to the legal theory, but we're just telling the story of what happened. So this ties back in to the client interview, where we were talking about the importance of us having the appropriate details of the case, because now we have to allege them in this document. And so every time we have this gap in our knowledge or in our questioning of our client, we're going to then have that gap in the pleadings, and we don't want that. We want to be able to basically answer all the question words related to our client's particular situation.